I am Tom Fields from Mentor, Ohio. I'm a victim of the negligence and lack of integrity of both lawyers and judges. You can get somebody privately to do it. Then you go back with the evidence that's been collected. They then can look at it and see at that point if they think you have enough evidence to proceed. At some point they might say, well, you know, you've got evidence there for a while, you collected, now we don't see enough to merit going further. Now it's up to you to pay, you know, if you want to, or collect your own evidence. If you collect more evidence, you can go back to that grand jury with more evidence, say, now have I got enough for you to proceed? And they can judge whether or not you have enough to proceed. So in other words, it starts off, though, that nobody's going to be denied the right, or nobody's going to be a gatekeeper to prevent you from going before a jury to show your evidence. So like when I was able to show fraud by a Supreme Court judge, you know, I never could get any accountability because even though another Supreme Court judge came forward and recognized the fraud, and even though the clerk of his court, of the Supreme Court judge's court recognized the fraud, there wasn't anything I could do because there wasn't any jury to hear it, because anytime no prosecutor would take it, just like in your case. So that's where you...
Just so you know, we've got the camera rolling. So,
sure, I understand that.
I didn't mean to stop you, I just want to make sure you knew.
No, that's fine. You know, I killed that point.
You got that one covered?
Yeah.
Okay. All right, well, you and I are going to carry on the conversation.
Sure.
And you've submitted a couple questions. While we normally wouldn't ask those right up front, I'm going to go ahead and do it to make sure we have them covered. What's your time code?
We're at 1955.
06, 1955?
Yes.
Okay. What's the principal lesson that you want to pass on to others, Tom?
The principal lesson that I want to pass on to others is that we cannot count on our laws to protect us against being taken advantage of, even during our final hours, while under a do not resuscitate order and on a morphine drip. Nor can we count upon our laws to hold accountable those who would take advantage of us under such circumstances. In fact, should our heirs seek to remedy the harm they suffer as a result of such crimes, lawyers and judges will take further advantage of them.
What legal reforms have you advocated in the 20 years since your father died as a result of what you experienced upon his death?
The legal reforms that I've advocated in the 20 years since my father died, and as a result of other experiences years earlier, I recognize that many legal reforms are needed to prevent legal abuse as the result of the negligence and lack of integrity of others, especially lawyers and judges. Because my father was taken advantage of during his final hours while dying of cancer, under a do not resuscitate order and under a morphine drip, I first proposed a legal reform which nearly addressed that set of circumstances. So the Senate Minority Leader here in Ohio introduced in 1996 my first legislative action, which developed from 1991 to 96. In a nutshell, what I proposed is giving you the right ahead of time to put in your will a demand that you would make of the courts that should you be on a morphine drip and under a do not resuscitate order and be signing financial documents, that the courts would be required to void those documents by summary judgment unless whatever safeguards you stipulated in this declaration in your will were met so as to prevent you from being taken advantage of and to protect your heirs. The Bar Association killed that legislation. They would not give you the right to declare ahead of time how to handle such problems. Now, why shouldn't you have that right? Everybody I've talked to says it makes perfect sense, but the Bar Association killed it. And I have a record online that anybody can go and see some of that record. Following that, I then, and there were 2 Legislative Service Commission memorandum done at the request of the Senate Minority Leader about that. And there was presented to me then some material from the Ohio Code dealing with self-proved wills, which itself is flawed, and years later I tried to address that loophole in the law that it created. There have been numerous reforms that I've tried in this area. There's been numerous reforms I've tried in the court reporting system to prevent, as I mentioned in the script to Congress, in my testimony before Congress. For example, I have posted the transcripts of the testimony of those who took advantage of my father and were involved in the case down in Florida, so you can see it. Now, since it's not official, it's not an official website, you don't know, unless you trust me, that I've done so faithfully. I want to be able to do that as part of the court reporting system, to link to the case, your evidence. You pay a small fee for what it costs to put things on the internet, a few dollars a month per megabyte maybe, if you're so committed to actually showing that evidence, so that everybody knows that that transcript is officially recognized. Why shouldn't you be able to do that? You know, the amount of the cost and the ability to do that is easy. There is a company that's been in business for over a decade now that basically creates a transcript at almost no cost when you give testimony through the typical court recording mechanism, Stenograph Limited. And their tools, CaseView 2, are actually used in the court system and gained notoriety in the O.J. Simpson case and the Exxon Valdez case because the judges and lawyers were using it to get a real-time transcript on their computer screens, which could just as easy, and it's text-based, which is just as easy to do on the internet or in the court reporting system at almost no cost. So there's some very practical solutions out there that are not being discussed, not being implemented, all because the lawyers and judges don't want to make it possible. You don't even have the right to this day to indicate in your court records to provide your contact information if you so choose you want to, so as to facilitate networking with other victims, like we've tried to do here. It's almost impossible to establish such a network. And that is because you can put your lawyers, your lawyer's information might be provided, but lawyers typically aren't going to provide their clients' information. It's very difficult to network, and so another simple proposal for the court reporting system would be to include your contact information if you want to, and to have the right to update it maybe once a year as far as what's online, so that if you switch internet providers, for example, and you want to change your email address, or if you have switched telephone providers and have a new phone number or whatever reason, all that information could be updated once a year, and if necessary at some minimal cost. There's a lot of things in the court reporting system that could be done.
All right. You indicate you've experienced legal abuse years before your dad died. Can you describe that experience and tell us what you learned from it?
That experience of legal abuse that I experienced years before my dad died is a lot more complicated in some regards and simpler in other regards than the experience of what took place at when my father died. The underlying issues are a little more complicated, and most people could not identify it. One of the reasons I've made the advocacy effort I have made is because I believed that people would want to know and make sure that their final wishes were upheld and not being tampered with, and their heirs not taken advantage of as a result of the conditions they're in just before they die. I thought that being on a morphine drip and on a do not resuscitate order, dying after your stomach has ruptured from your cancer, would make a difference to people. And those who have listened, it has made a difference too. But again, the word is not getting out because the media doesn't want to let the word out, because the lawyers and judges don't want. In fact, my case was never reported by the media down in Florida, was never reported by the court reporting system, other than acknowledging that I made appeals. Not a single fact from the case was ever reported by the media in Florida or by the court reporting system. This is why, again, I proposed legal reforms to address these deficiencies in the court reporting system. Now, the experience years before occurred in Montana, where I remained for a time after I served there in the Air Force. I ended up in a dispute with an employer, which ultimately led me to be defrauded by a Montana Supreme Court judge. I did my best to expose that fraud, and in the end I had some success. However, this took such a toll on me that I attempted suicide as a last recourse to holding this dishonest judge accountable. The principal lesson that I learned from this experience is that my conclusive evidence of a Supreme Court judge's fraud was practically inconsequential. That still impresses me as the most important lesson I have learned from life. Even more important than what I subsequently learned about the legal profession's responsibility for taking advantage of older adults whose mental capacity and ability to resist being exploited are severely compromised.
Wow, so you got so frustrated with the system, is that what I understand, that you tried to commit suicide, or you?
That's exactly right. I went with a gun into the judge's chambers and tried to commit suicide. Then I called when I didn't have the guts to do it, I called police and had myself arrested. And because I did that, I was convicted of a felony. I didn't have to serve any time because everybody, even the judge, knew that I'd never intimidated anybody other than tried to commit the suicide. But what happened is that my father's wishes were then further subverted because he appointed me as executor of his estate and to benefit my own children. And they used the fact that I'd been convicted of this crime to remove me as executor of the estate. And they put in place the very people who had been my father was being taken advantage of by several people associated with the family, and lawyers and others. And they appointed one of the people who had tried to take advantage of my father. In fact, that individual, right after my father died, insisted that I make her co-executor of the estate, which I refused to do, walked out of the law offices. This were the offices of lawyers my father had hired, that she had arranged for them to hire just a couple of days before, trying to get what she wanted. I said we would go by his will, and that's what we would go by. It was in a safe deposit box and by his trust. That didn't meet her satisfaction. She wanted a 50-50 split in the estate because, you know, we were equal siblings, but my father's estate, as his documents show, were for the benefit of my children. She had no children. Also, she didn't get along with my father, as others have testified to. So the bottom line is, I don't know, I lost track of where I was at.
Well, you were so distraught that you were close to trying to take your own life.
Yes, and even the media in Montana quoted the law enforcement officials and the judge that, you know, I didn't do anything other than try to take my own life.
And how long were you in the Air Force?
2.5 years.
Had you ever been arrested or anything?
No, in fact, the Air Force, I was very unhappy in the Air Force, and it's a long story. It goes back to the Vietnam and the way what it does to people who have careers and education, and how it disrupted their lives. And so that's a large part of my background, but again, that gets a little far afield here. And I was given 10 days after 2.5 years to get out of the Air Force. I was a Deputy Missile Combat Crew Commander, which is a fancy title for doing nothing. And basically, what led to my early release was that I was evaluated by the Inspector General in its inspection of the base, and according to the Vice Wing Commander, a fellow named Kendall, during my exit interviews, he said the Inspector General rated me the best person in my position in the country. So even though I hated the military, I did my job to the best I could. I had a lot of faults because I was so unhappy, but you know, again, I knew what I was doing and did it well. I never believed the fact that actually I was rated that way, because in the evaluation, where they take one crew and they run them through the simulator, a couple crews, and they take them through the simulator, not all crews, my crew actually made a mistake, which we had never done before. So I found it amazing that I could be rated so highly by the Inspector General and yet still have made a mistake. So I think it was more or less used as an excuse to give me the ability to get out of the service.
You are quite an advocate for the elders, against elder abuse and guardianship abuse. And have you prepared any material that would help others to be better prepared for what might happen to them?
Yes, I've prepared a lot of material, some of which is online and some of which isn't. I stopped putting things online several years ago when my account for AOL was subverted. And even when a Time Warner attorney tried to correct that, AOL was adamant about not giving me access to my own website, which I then ported over to Roadrunner, and Time Warner Cable, but which is still under the same umbrella as AOL, but they're distinct. And I haven't updated it since. But the Attorney General has a Elder Abuse Commission here in Ohio, and I've been acquainted with the chair and others for years before the commission began, and was invited to present to the commission material back in September of 2009. And I've basically recommended an intervention strategy to prevent the kind of abuse that my father experienced and that my family experienced because of that. And it's basically a 5-step protocol that's based on a recommendation by the American Medical Association. And so I prepared a document which includes the American Medical Association recommendation and other references from other medical authorities, and there's quite a few of them. It includes that ABC News video that I referred to in the video that in the presentation, my interview with my testimony before Congress here. And the 5-step protocol is pretty simple and basic and easy to follow. The first step is it uses a checklist to identify situations which involve individuals with severe cognitive impairment and so require the rest of the protocol to be followed. And I have here a copy of the kind of checklist and what would be on it. So for example, if a lawyer in that ABC News video goes in to see the patient as he did, who's already been found incompetent, this checklist would be used because the attorney would be required before doing that to stop at the office of an ombudsman or risk manager at the hospital to identify that he was going in for such a task. They would then look at the checklist and compare the condition the patient's in with the conditions in the checklist. Finding that the patient was in one of those conditions, they would then initiate the rest of the checklist, which would require an independent examiner to go in to find out if the patient even expected to see this lawyer, if the patient had any kind of intentions of doing anything. Just open-ended questions to find out who was driving it. That's key to finding out if there's undue influence, for example, and if there's fraud going on. So the checklist is very important, and that's one of the reasons why I've included an example of what the checklist could include. Step 2 then has an independent examiner ask the transfer open-ended questions to learn what business, if any, he wants or expects to conduct at this time. Step 3 is to have an independent examiner ask the transfer to provide details about what he expects the document to include. Step 4 is to have an independent examiner ask the transfer questions which others might reasonably want to ask if they were present, including questions about the transfer's understanding of the suspicions that his signing the document might raise and the transfer's ability to address those suspicions. And then the last step is to have an independent examiner explore potential conflicts between the transfer's expectations and the content of the document. It's clear that such a protocol addresses what most medical and legal authorities recognize but fail adequately to address, namely cognitive impairment is a disability, and secondly, the more severe the impairment, the greater the disability and susceptibility associated with it. Again, anybody who wants to see this document can get it from me easily by using the contact information I provided previously. It's of special interest to me several things. One of which is the Investor Protection Trust, which came out of a lawsuit with the financial industry because of their taking advantage of people, have made a lot out of trying to address the financial exploitation of people who are mildly cognitively impaired, which they define as a person who has some problem with their financial, with handling their finances, but can carry out their day-to-day activities otherwise. I have focused on the fact that we don't even have laws to protect and handle correctly the situations involving people with severe kind of impairments, people who cannot handle their daily affairs, somebody on a morphine drip, somebody with advanced Alzheimer's disease. They continue on their merry way giving advice which doesn't do anybody any good rather than addressing the real problem. I'm very critical of people who do this, and it's almost ubiquitous in the field that I work in, that I advocate in, whether it's adult protective services or others. They're always doing things the wrong way. Detective Rubichuk, in his book, Financial Abuse of the Elderly, A Detective's Case Files of Exploitation, brings out that very point, telling you that what the advice that is being given to seniors who are cognitively impaired is just worthless. And plus, those who would say that we're giving advice to people to prepare them ahead of time before they get in that situation so as to protect them are ignoring the fact that there's nothing you can do basically to protect yourself. My father followed their advice. He had a will, he had a trust, he had talked to lawyers about it, he had a prenuptial agreement, he did everything. He kept it in a safe deposit box. It made no difference, because the safeguards that are needed are not there, and the Bar Association and the legal authorities are the ones who are making sure that the safeguards are not there. In fact, I testified before a committee about safeguards that the Bar Association is responsible for removing, historically removing. For example, with regard to Senate Bill 302 in the regular session of the Ohio Legislature 2007 to 2008, the Ohio Legislature changed the provisions of the code that really weren't much protection to start with, but are now even less protection. When you sign a will, historically, somebody had to...
It's all right. Just hold just a second. Let's see what we got. Hello?
Are you filming? I'm sorry.
We are? You want to come in?
Yeah, sure.
Want me to cut or?
No, we can
Sorry.
just keep it rolling. I've got a time code. Come on in. I'm Bill Windsor.
Kind of
I'm
blocked
Lynette
off the
Thomas.
door.
Hey, Lynette, how are you?
Pretty good, how you doing? Excuse me.
Pull
Hi,
up-
Lynette, that's
pull up
fine.
a chair.
Where?
You can sit over here with us.
Oh.
If you like.
Actually, this looks good right
And
here.
Bill, you said you'd like to kind of vary up the shots, kind of getting close.
Absolutely.
Punching close.
Yeah. All right, go ahead, Tom. If you remember where you were, pick it up.
Sure. I testified before a Senate or House committee, House or Senate committee in 2000, 2008, 2007, 2008 about legislation that was passed that removed a protection that had been there historically. Individuals, even today, expect somebody, when they sign a will or other document that's important, for it to be witnessed by two people who attest that you're actually the one who signed it. That protection has now been removed. I testified that that bill could not be for the purpose stated by its sponsor. And I have here the testimony. Again, I can send it to anybody who wants to. I also have a copy of the bill. After I did so, an internationally recognized expert in this field, Dr. Bennett Bloom from Arizona, wrote me that, in fact, he also came to that same conclusion. He did so on medical grounds. I came to just on the grounds of the bill itself and what the sponsor had stated in a video produced by the legislature, as well as in his testimony. Again, I gave my testimony based on that material, that it could not be for the purpose that he was stating. It turned out that several other states, about a dozen, had previously passed such legislation, and others have since. They were addressing a real problem, but they wouldn't tell the public the real reason. They were trying to make it sound like that they needed this because there was a problem trying to get people to witness documents when the individual who was signing the document had a communicable disease. In fact, that's what they said. It was that Dr. Bloom said was not, a valid reason, because there was no reason why they could not, as they have always historically, don a mask and gown for such purposes. And at worst case, you could always put them behind a barrier that you could see through and hear what's going on. They removed this so that you had to be, in quote, the conscious presence, but that conscious presence was never defined in such a way that it would apply, first of all, only to those kind of situations. It now applies to all situations. It was never also applied in such a way that you could hear what was going on if it was whispered. So I have individuals who have told me, and I have not experienced this myself, but I have individuals who have told me that wills have been signed by people who thought that they were signing birthday cards. That's because they didn't know what they were signing and because they were being taken advantage of. And again, if you're not there close enough to know what's going on and taking enough of an interest, you wouldn't know. And of course, like I said, that protection wasn't much of a protection in the first place because, as in my own father's case, the witnesses were part of the problem. I think that really, with the interview, covers a lot of what I want to address.
I'll ask you a couple of few questions. We'll wait till-
He's filming right now. Can I take a message? Wait a minute. Who is Roseanne Miller?
She is in Columbus.
She's a state coordinator.
She's in Columbus.
Does he need a phone number? He or she need a phone number?
Tyler, if you want to ask any questions, you can feel free to ask questions too. When they filmed me as part of the National Council on Aging project with the Human Rights Group Witness and the Elder Justice Coalition, the camera person actually asked a question, which is in their video. So, I'm open to questions even if you have them.
Gonna be
Yeah, if
filmed,
something comes
so
up,
I
I'll
can't.
write it down on here.
Sure.
I don't know what to tell you.
Kind of just.
Same for anybody else if they want to ask questions.
What does he need? He or she need?
Wait a minute, he's supposed to be filmed tomorrow in Columbus, but he doesn't get off at, you don't get off till when?
It's called Roseanne.
5:30.
Tell him to come when he gets off. I'll film as late as needed.
He'll film as late as you need.
Yeah.
I do want to add something. You ready? This is specifically relates to what another person Joe Rudy Setensek is going to be addressing during his interview here. This involves a Trumbull County probate judge named Tom Swift specifically. I have a different angle on this than Rudy because I have no case before Judge Swift specifically. But I was introduced to Judge Swift back in 2003 by the individual who was Chief of Adult Protective Services for Cuyahoga County named Carol Dayton, a person who has done more to try to create a dialogue in the state than anybody else has on this. Not that she agrees with everything I say, but again, there's a lot about Carol and my relationship that I could discuss, but that's irrelevant at this point, just to know that Carol is what introduced us back in 2003. At the same time that Carol asked me to attend a annual conference of the Consortium Against Adult Abuse because she believed that and wrote that what I had provided her was both clearly presented and persuasive. And she thought that Judge Swift should hear it and that he should take it into consideration. And Judge Swift, I had one conversation with Judge Swift on the phone, and he indicated that he would find unconstitutional what I had proposed. Now, what I had proposed that we were talking about, I believe at that time, well, I think that actually was still the original proposal that I mentioned about giving people the ability to protect themselves while on a morphine drip. Anyhow, I did ask him why he would find it unconstitutional, and he refused to answer my questions. And in fact, the interview that was videotaped at the Attorney General's office in 2009 is that half-hour video. Most of that video is an exchange between myself and Judge Swift going back to that 2003 period of time, in which, if people would watch the video, many people have watched it, believe he was trying to mislead others in the commission that he's part of. Anyhow, I have repeatedly asked Judge Swift and others questions as to why it would be unconstitutional, with a special focus on the following. One of my proposals is that you should be able to have what I call a conditionally irrevocable trust to protect yourself in those situations. And basically, a conditionally irrevocable trust would operate in the following way. It would be a revocable trust, like the living trust that they try to sell you through the legal profession all the time, that you would have complete control over and the ability to revoke. But that revocability that trust would become irrevocable upon the satisfaction of some operative condition that you specify in the trust. And that condition might be that you are placed on a morphine drip under do not resuscitate order. So the issue is, should you be allowed to have such a trust that becomes irrevocable as soon as you're put on a morphine drip? Judge Swift indicated that he would call it that would be unconstitutional too. So one of the questions I asked him, just to give you an example of the kind of questions I've posed, and again, if you contact me, I can share with you the questions that have been asked. Why should an irrevocable trust be legal, which gives you no control over your property from the moment that you execute it? But why should you be able to give up control of your property then, but not delay the giving up of your property to when you really want to impose the irrevocable condition, which is when you're placed on a morphine drip?
Tom, I'm going to stop you. Sherry apparently needs to leave.
Sure.
Because I don't even know that lady, and she brought me here, and she's been waiting 3
Okay.
years.
Where did you come from?
South Euclid, Ohio.
All right, so that's just right around here.
Yeah, but I don't know the lady, and she.
All right, but if we get you a ride back,
I can get.
Are you okay? You want to just go let her go and then we get you a ride back? I hate for you to have come and not get filmed.
Yeah.
Where
I
do you
did
live?
either. At this point, wherever. So, I'm from Stowe, but that's no problem.
Where in South Euclid do you live?
Cedar and Warrensville Center.
I was born there. I could get you back.
So somebody give you a ride. So
Yeah.
if you want, we can do that. If you want to just go ahead and go.
You know where Eastway is?
Pardon me?
You know where the street Eastway is?
That's where I live.
That's where I was born.
I live on Eastway.
Maybe in the same house I was born in, who knows?
All right. good.
About the
We
middle of
need
the
to
block.
Go decide, and if you come back, we'll be delighted to
Okay.
have you. And if you don't,
Okay.
we'll do you on the internet.
Okay. We're still rolling.
Where are we?
Well, I was
No
mentioning.
wonder I messed up Cleveland.
Looney
No,
bin.
Just teasing. Everybody's got their own issues. Are we rolling?
So we're on.
I was mentioning that Judge Swift and I had a conflict over the constitutionality of some safeguards. And I mentioned a conditionally irrevocable trust, which I described as a trust that would become irrevocable upon the satisfaction of conditions that you specified in the trust, but remain revocable up to that time. And Judge Swift said he would find that unconstitutional. Now, it turns out that a New York attorney named Celia Clark advertises in New York such a trust, and I've been in contact with her, and there's never been any issues in New York State. And yet Judge Swift has blocked the efforts that I've made along those lines and said that he and other judges here in the state of Ohio would declare it unconstitutional. The questions I've asked have not been answered by Judge Swift and others. I've asked others to try to get answers. A well-known attorney in Cleveland in the estate planning area is Armin Budish, who in 1997 published an article in the Cleveland Plain Dealer called "Where There's a Will, There May Be a Loophole," which he did because I approached Plain Dealer editors asking them to ask him to address the issue. And at first he refused to in 1996 when the first Plain Dealer editor asked him to. They don't control his content. You know, they like to use his content because he has a following. And in 1997, then another Plain Dealer editor asked him, and at that point he told me that he didn't, when I asked him why he didn't publish it in 1996, he said the Plain Dealer didn't want him to, which didn't make any sense to me since it was the Plain Dealer that was asking him to. But anyhow, all that being said, Armin Budish did publish an article, which he also has televised in a program called Golden Opportunities, this essay of his on where there's a will, there may be a loophole. And again, if you want to see the article, I can share it with you. It's not as good an article as those that are included in the references that I cite by people like the President of the American Academy of Psychiatry and Law and others, because he tries to lead the impression that the courts can be trusted to try to do their best. He doesn't go into why the courts cannot be trusted, why you, as the President of the American Academy of Psychiatry and Law notes, because evidence is not collected in the timely manner that it should be and in the way it should be, a lot of these cases are left to the presumptions of law and the circumstantial evidence, which basically gives the courts a free rein to do what they want. But anyhow, now the thread with Armin is interesting. Again, I contacted Armin very early on because of his notoriety in the estate planning area in the area. It turns out that in 2006, he was elected to the state legislature for the first time. His first time I think he ran, and he won by a large margin in his district. Now, it turns out that before he took office, that was the same year that Governor Strickland was elected to office. And prior to taking office, Governor Strickland appointed some review teams of various departments to prepare his administration for the upcoming tasks. And one review team he appointed people to was a Department of Aging review team. It turns out that I was fortunate to be appointed to that review team along with Armin. That's when I learned that Armin was actually a state legislature and had run for and been elected. Armin assured me that he would get those questions answered, and he would pose them to the State Bar and to the Attorney General's office. And I have correspondence from his office saying that they did pose the questions. I never got any answers still. I've had other authorities, including the chair of the Ohio Coalition of Adult Protective Services, former chair and the gal who now chairs the commission that I mentioned, the Ohio Elder Abuse Commission, also told me I would have the opportunity to get those answers. I've never got those answers. In Armin's case, since he's an expert in estate planning, he could have addressed the questions on his own. He didn't have to have the State Bar or the Attorney General. He could have addressed them, but he never did, because Armin, in my opinion, has never been sincere. It's one of the conflicts I have with Armin. In fact, one of my conflicts with Armin comes about when I asked him to find me representation to replace representation in Florida. He did such a thorough job in trying to understand my need. He actually recommended the very lawyer that was abusing my father and that the lawsuit was filed against. You know, I've had that kind of experience. This is the kind of negligence that you run into every day with attorneys. It's not as serious as much of the other material. And so again, that's a point that I wanted to bring up the experience with Armin and Judge Swift, because it relates to Rudy's experience.
All right. We've got about 5 or 6 minutes left. I want to ask you for some 30-second soundbite responses.
Sure.
30 seconds or less. What exactly happened with your dad?
My dad was known to be near the end when his kidney, when he developed renal cell carcinoma about 4 or 5 months before he died. He was down in Florida. I worked for the Cleveland Clinic. He asked me to check with some people at the clinic. He had his kidney resected down in Florida. As soon as he came home from the hospital, he complained that his second wife, who he married as a widow, marrying a widower, was trying to get him to sign over some property to him, which was contrary to his wishes in the prenuptial agreement they had, which protected both of them. In fact, one of the interesting aspects of the case, as the evidence shows, her testimony, is that she lies for almost 100 pages of testimony saying that they had agreed to disband this, to ignore their prenuptial agreement near the end of my father's life, and a year before he died. And yet we subpoenaed her own will, which was after the point she said that they had done this, and she invokes the prenuptial agreement in her own will. And when asked about that, she says, well, that's just the way it is. In fact, in asking questions about the prenuptial agreement and its binding nature and whatnot, she's asked before her testimony to answer interrogatories. Her interrogatories completely contradict the answer she gave under oath in the testimony. They both were under oath, but in her live testimony. The reason is because it's clear that she didn't prepare the answers to the interrogatories. Her daughter, the lawyer, did, and her daughter, the lawyer, lied. There's so many lies that are easy to prove, in which I try to do on the web pages I put up by showing people where the lies are. But anyhow, so a couple months before my dad died, he had his kidney resected. Over Christmas, he said, "Don't come down yet." He said, "Wait till I'm healthy enough to have, to do something with you," because that's the way my father and I, the kind of relationship we had. And he knew that I had two young kids, ages 3 and 8, that required a lot of my time. We were supposed to come down for spring break, but his cancer metastasized in early March, late February, early March. About a week or 10 days before he died, he asked me to come down at that time. The conversation was such that I knew that he was a little disoriented because he told me somebody was trying to take advantage of him. I asked him if we could wait because I had some business that was being conducted with out-of-state folks at the Cleveland Clinic that was very important for the Cleveland Clinic. He said, "Fine, wait till after that business was conducted." So I waited past that weekend when they came in. Everybody knew that if I got a call from the doctor that I was still, even though I was the person leading the effort on behalf of the clinic in this business, everybody knew I would have to leave. It turns out that that morning that I was training people on the new software that I was responsible for at the clinic, the computer crashed from their software. We had all kinds of problems, and I got a call from the doctor saying that my father wasn't going to make it past the end of the day. At that point, I had to leave the clinic, and I had to leave people up to their own devices to overcome the problems. By the time I got down to Florida, the doctor had written a will in my father's medical record, which he testifies in his testimony was atrocious. He finds out that my father actually had a will when he had been told that my father didn't have a will. It wasn't actually a will. Nobody tried to probate it. It wasn't a will. It didn't even address. All it addressed was the interest that one of the perps had, who was trying to take advantage of him. Even that perp didn't try to probate it because of the fact that nobody thought it was a will. But what happened is the doctor, not having the kind of intervention protocol that I proposed, that's based on the American Medical Association recommendation for such a protocol. What he next did is he then told those, including the perps, what he had done, the other perps, what he had done, and they seen that my father would sign documents he wouldn't normally sign, then went and took advantage of him. And then instead of consulting the doctor who had written what he had done in the medical record, and which contradicted what they did, and the doctor testified it was a clear contradiction to what my father had told him just hours before, they went and got a doctor who was one of their friends and asked him to okay it, and he wrote right underneath that doctor's note, it's okay, but never consulted the other doctor. He also said he did so as their friend, and he thought that their friend was my father's spokesperson. Why would my father need a spokesperson if he was competent? The evidence is abundant that he wasn't competent, that he was being taken advantage of. In fact, we have written documents from the lawyer's own law firm 12 times while my father was not under the morphine drip in the months before he died of the cancer. They had tried to get my father to sign over some property or give them some rights to that property before he died, and he refused all 12 times. In fact, he refused to even give the widow the right to stay in the property for 2 years after he died because she refused to pay out of her own $1 million assets the upkeep of the property. She wanted his estate to. She was worth more than he was. It isn't a matter, as a lot of people seem to get the impression that, oh, we lost and that's what we're complaining about. The fact is, my father was robbed by an attorney. I had prior experiences with dishonest attorneys and judges, and here was another example of a dishonest lawyer and judges getting away with crimes. I tried to commit suicide, and in an experience which I felt many people would not understand, and therefore I didn't try to advocate. Again, when a person's on a morphine drip, I thought people would understand. I thought that that was where I drew the line. I felt that I could expose all that and let people see exactly how the legal profession works, which is exactly what that ABC video shows, which is why in 3 minutes people can see and can know by watching the video and reading the ABC report just what attorneys will do, and know why we have to protect the public against the attorneys and the judges. That is the most important thing that we can come out of, in my opinion, can come out of this movie.
Let me ask one last question. We have about 30, 40 seconds. What do you want to say to all the people out there who have elderly parents or folks like me who are going to be at that point in 20 years or so?
The most important thing that I can say to people who have elderly parents who are thinking about when they get older is to correct misconceptions, the misconceptions that are brought about by the bar which have permeated society. The fact is that this does happen. My father never would have believed it could happen. I've had older adults, typically people who are now my age, say, well, I forgot a will, all this is, I'm protected against all this. Well, my father had the will and he thought he was protected against all this. You're not protected. You've been lied to by legal authorities to think you're protected. The fact is the last document you sign is the document that will be upheld, and the courts here in Ohio and elsewhere have said that even if you're delusional, what you sign will be upheld unless it can be proved that the delusion was an insane delusion and it caused you to sign the document. Well, how are you supposed to prove that that delusion caused you to sign the document when you're dead? Obviously, if you didn't sign it beforehand and you sign it then, obviously it caused you to sign it. But that's not the way the courts rule, even after they state that those are the conditions. And what's the difference between a delusion and an insane delusion? If you're delusional, aren't you just delusional? And that was in the case Bevan versus State of Ohio. And I think that was it, Bevins versus State of Ohio. It's cited in the Ohio Legislative Service Commission, page 6, done in 1994 in response to my original proposal. Again, the Legislative Service Commission memorandum, I posted that online. You can, and all the material related to that before and after. For 20 years, I've been addressing this farce that's been posed to the American people by the legal profession. The problems that we have in this country with the legal profession are the same that they have in every country with the legal profession. It's the same problems that they had in Nazi Germany when Nazi Germany, and many people of Jewish descent have said that they see here what's going on, what same kind of things that went on in Nazi Germany. Nazi Germany, prior to the disaster, was reputed to have one of the best legal systems in the world. Very highly reputed, very respected, very authoritative, just like the legal profession here. Look what happened. You cannot trust your legal profession. I'm not an expert on the Founding Fathers, but my impression has always been that that they didn't even really give much power to the federal court system because they were afraid of the abuses of that court system. We're talking about the state courts, the local courts, the state courts. They're all not trustworthy. You need to have safeguards to protect against all of them, and we don't have protections needed to protect against any of them.
It's a wrap.
Thank you.
True.